Shalom, my name is Michael Decker, and I'm a lawyer within the law offices of Cohen, Decker, Peckham Rosh. Today I wanted to discuss the most recent Supreme Court decision regarding the recognition of reform and conservative conversions within Israel for the purposes of the law of return. A lot of rumors and disinformation, in my opinion, has been spread on the matter all over the place. And in this video, I wanted to clarify this recent court decision and to explain why it wasn't such a dramatic decision if you actually think about it and if you learn all the developments that occurred in the last 15 years in this regard. First of all, it's important to note that we're dealing here with a decision that's only relevant for the purposes of the law of return and for the civil definition of who is a Jew according to the population registrar at the Interior Ministry. So we're not dealing here with the religious definition of who is a Jew, and specifically, therefore, this decision of recognizing these petitioners as Jews for the purpose of the law of return has nothing to do with the rabbinical court and with the ability of these petitioners now to marry and divorce in the rabbinical court and to be recognized halachically as Jews according to the Orthodox definition of who is a Jew within the mainstream Orthodox Jewish religion. So basically, the legal question that was dealt with in this recent decision was whether reform and conservative conversions within Israel should be recognized for the purpose of the law of return. In this regard, it's important to note that already in 2006, it was determined that conservative and reform conversions are recognized for the purpose of the law of return, but we're dealing here with conservative and reform conversions that occurred outside of Israel. And these petitions in the recent decision were submitted 15 years ago. And for 15 years, the Supreme Court wanted this specific question of whether conversions within Israel should be recognized for the purpose of the law of return. The Supreme Court wanted the state of Israel to make a decision on the matter, and all the precedents already existed to approve these conversions for the purpose of the law of return, but because of politics, the state of Israel didn't want to decide. So eventually, after such a long time has passed, and because we're dealing with infringement of very basic civil rights of Jews living in Israel because they converted into recognized Jewish denominations, the Supreme Court had to finally make a determination. It's also important to note that already conversions within Israel, Orthodox conversions that were not done through the rabbinical court, were also approved just recently by the Supreme Court, so that an Orthodox conversion that wasn't done by the rabbinical court, because even within Orthodoxy in Judaism, you also have political differences, and you have Orthodox conversion centers that are also conducting conversions, but they were not recognized either. Only the conversions through the rabbinical court were recognized, and the Supreme Court did recognize already Orthodox conversions within Israel for the purpose of the law of return recently. And therefore, the only natural development and stage in this process is now to also recognize the reform and the conservative conversions that were done in Israel. So this is basically what happened. So now the petitioners that petitioned already 15 years ago will be recognized as Jews only in the Interior Ministry and only for the purposes of Aliyah to Israel in accordance with the law of return. I hope this video helped to clarify the situation. If you have any further questions or clarifications on the matter, you can feel free to contact us, and we'll be happy to respond and to give you the best advice we can. Thank you very much for your time.